Just everybody know that the YouTube's on. If you want to have private conversations, I can give you breakout rooms right now. But we're just waiting at this point. Ms. Driver, I know one of your clients is here, and Ms. Peterson, Mr. Leonard, and Mr. Royal. I've got a number of your clients here in the waiting room. If you guys want a breakout room, I can do that now. If you're fine with them in the waiting room at this point, I can leave them in there, whatever you want to do.
I don't think we need a meeting in the breakout room, Judge. We're ready to begin as soon as the city attorney arrives.
Fair enough.
Agreed.
Yep, same here, Judge. Thank you.
You're welcome. So when we're ready to go, I'll bring everybody into the Zoom meeting room, and then I'm going to ask that everybody mute except for the attorneys.
Good, Judge.
And as you guys see, I'm still trying to figure out how to do this in a way that's that we can all see each other and hear each other. So if anybody has any suggestions, I'm open to it.
We're all trying to get used to the new procedures, Judge.
Well, you know, I don't think they're bad necessarily, but I think we're all trying to figure out best ways to do them. And I'm here, I'm just doing a little work in between.
Shannon.
Hey, Shannon.
Good morning, Mr. Royal.
Good morning.
Sorry I was late. I was caught in Judge Garrett's courtroom on some other kind of matters.
We know you're practically having to cover the whole court by yourself, so we recognize the difficulty you have.
I actually have staff here, but we are 4 people short. I lost 2 people to transfers. Ms. Mullins got elected judge in Southgate. And
Oh, really?
And Mr. Schwartzberg retired.
Good for her.
Yes. And she had another baby.
Oh my gosh, she's been really busy.
How you doing, Ms. Walker?
Who's that?
Good.
Oh, hey, Judge, how are you?
I'm good. Happy New Year.
Okay, now I can see you. Happy New Year.
I'm hiding out in the back, but
Not bad.
what was I gonna say? Yeah, I know you guys have been super short since the beginning of the year.
Yeah, Ms. Mullins is judge in Southgate. Mr. Schwartzberg retired, and then Mr. Smith and Ms. Nemi were transferred to other units. So I'm down 4 people.
Whoa.
Yeah, we're interviewing Tuesday though. We're gonna hire 2 more.
Oh, that's pretty good.
Yeah. It'll help balance out a bit anyway.
Yeah. Well, yeah. So far, I like Ms. Rogers in this courtroom. That's been fantastic. Thank you.
Good. I'm glad that works. I'm glad.
Yeah.
She has 3 courtrooms, so she appreciates your patience. Like I said, I've had to,
I know she's running, so whatever you guys need from us, to make it easier, let us know while we're waiting. I got one more person in the waiting room who I'm not sure who it is. Or maybe they left. Okay. So I'm gonna bring everybody in the room. Then I'm gonna call the cases. I'm gonna try to put on the record the folks that we have here. But note that all of your clients' appearances were waived for this hearing at our previous hearing. So let's do it. It's all. Just waiting for a moment because it takes a little bit of time for folks' audios to connect. So we'll get
Okay.
started in a second.
All right.
There's Danielle.
Gabriel.
Okay. Good morning, everybody. My name is Judge Williams. If you are a defendant in this case, I'm going to ask you to please mute your phone. We've got a lot of people in this room, and it'll be a little bit easier for us to communicate. We all kind of talk one at a time. What's going to happen first is I need to put all of the cases on the record. Then I'm going to ask for the attorneys to put their appearances on the record. And then I'm going to try to name all of the defendants that have that are participating today in this hearing. Note that your presence was not required, so anybody that's not here is not going to be penalized for not being here right now. Mr. Potts, it looks like we've concluded the first part of our docket. So you're welcome to stick around, but you're free to leave.
Thank you, Judge. Have a good one.
You too. Okay, so let me call the tickets. This is City of Detroit versus Danny Blade, case U563-06820. Darren Bullock Howard, case U560-36620. Noel Berger, case P1106-941 and SP1106-941, 2 and 3. Giovanni Barnett, case SP1106-940. Aaron Briggs, P1106-921. SP1106-921, counts 1, 2, and 3. Justin Barber, SP1104-319. SP1104-319, counts 1, 2, and 3. That's the same thing. Cheyenne Brown, case U575-80520. Daniel Burris, U567-45520. Andrew Bradley, P109-8306 and P109-8307. Kyle Beavis, U560-39220. Robert Baker, P108-9212, P110054, P110055. Gabriel Behrensdorf, U565-22820. Spencer Blakely, U560-38820. Stephen Barnyard, case U565-09720. David Barron Vega, U565-06620. Kyle Barnett, U565-15720. Justin Bass, excuse me, case U565-24520. P11078, strike that, P1107380, P1100050, Nicole Battle, U56512820, Aurora Barkman, U56524420, Eric Broadnax, U565142, strike that, U56514120, Isabel Boyer, U50372120, Claire Bowman, U565160, and P1098605, Grant Bennett, U56531420, Vincent Buckles, U56030820, Sebastian Black, U56707620, Maximella Beeman, excuse me if I mispronounced that, U567, strike that, U57057220, George Blanton Jr., U57613820, Javier Wheeler, U576062. Actually, okay, was there anybody's cases that I did not call that you guys could name off the top?
No, I think
I'm
you
not
got all
sure
of our
about
clients,
that.
Judge.
Okay, starting with Miss Driver, could you put your appearance on for your clients?
I did. It should be Julia Bell and Elsie Bolger.
Okay. From the NLG group, I've got Mr. Royal, Mr. Chambers, Ms. Peterson, and Mr. Leonard. Is there anyone else? Oh, and Ms. Cataray. Is there anyone else from your group that's here?
No, Your Honor.
You guys want to put appearances on?
Yes, Your Honor. May it please the court, John Royal, P27800. I'm lead counsel for purposes of today's hearing. The actual group of attorneys that's representing these defendants is the Detroit Coordinated Defense Coalition, providing pro bono legal representation for arrested Black Lives Matter protesters arrested in Detroit from the months of May through August. We're collectively representing the group of defendants that the court already put on the record.
Okay, I didn't mean to misrepresent Mr. Royal. Mr. Chambers, Ms. Peterson, it's not necessary, but if you want to say something or put your appearance on, that's okay.
Artie Chambers on behalf of the defendants.
Angela Peterson, P59116.
Ms. Cataray,
I represent defendants in another courtroom, but Danielle Cataray, P77162.
okay. Person identified as busy and busy. With the Nike shirt on, sir. Can you tell me your name?
Eric Bellamy.
Okay, Mr. Bellamy. I'm just gonna rename you in the chat.
Judge, this is Shanta Driver. Can you double check for me? I'm sorry. I was kind of listening when you were calling the cases, but I want to just make sure that Julia Bell and Elsie Bolger's cases were called.
Oh, you know what? Let me make sure.
Shannon Walker for the people, P53794. Neither of those names appear on the motions that I received from Mr. Royal and his group of attorneys. So I'm not aware of those two cases.
They're okay.
Meetings I received.
Miss Driver and her partner have been representing them from the beginning. Excuse me, one moment, everyone. Okay, back on the record, first and foremost, Mr. Bellamy.
Yes.
Okay, sir, we've got a number of cases that we're gonna have to handle that's gonna take some time before we can get to your case today. I'm gonna ask you, we can either put this, I'm gonna have to put this on another day. You can come back tomorrow if you want, but if there's a better day during the week for you next week, let me know and I'll adjourn it to that date.
No, tomorrow is fine.
Okay, so we'll set this matter tomorrow at 8:30, okay?
See you then.
All right,
Thank you.
you're welcome. Ms. Bies, if you can hear me, if we can set Mr. Bellamy's date for pre-trial and review to tomorrow at 8:30, and just let probation department know.
Okay, I'm gonna let them know right now. Thank you, Judge.
You're welcome.
Okay.
Calling State of Michigan versus Julia Bell, case SP 110006. Like that. SP 11000161. And LC Bolger, case SP 1098291.
And Judge, on behalf of the people against Shannon Walker, P53794, those two names don't appear on any pleadings that I have received.
I would note that Ms. Driver is separate from the coalition group, but I would note that her two clients, as well as her co-attorney,
Monica Smith.
yeah, Ms. Smith, have been making motions and participating in these proceedings since our first pretrial back in October 6th. So we can either catch up to speed with that, but I don't know any reason to believe why we shouldn't be able to proceed with Miss Driver and her cases. She's been on. She and her co-attorney have been here and have made not only motions in the record, but I've seen written motions from both of them. So I don't know if it's you or someone else in the office would have that.
Judge, can you tell me the date of the offenses and what the offenses are? I have no idea.
Okay. As to Ms. Bell, she's charged civil infraction for blocking traffic and a misdemeanor charge of disorderly conduct from an incident from July 23rd, 2020 in the area of Glendale and Auburn. And that's consistent with my other tickets from July 23rd. They're all from that same area, Glendale and Auburn. As to Mr. Bolger, he's charged one count of blocking traffic and one count of disorderly conduct from an incident that took place July 16th, 2020 at an area in front of 1268 Westwood, which I believe was the school bus. And I would note that I have one of the coalition's tickets from that date as well. And I don't want to spring this on anybody. Miss Ms. Walker, if you need copies of the tickets, I have them right here. I can bring them down to you.
I would, Judge, and I just would lodge an objection. There was no pleadings that I received for today's date regarding a motion to dismiss for either of those cases.
Okay, I've noted your objection, but at this point, I feel that there's enough information to proceed. So I'm gonna take 5 to, make sure that you have these tickets, and we'll be back in a moment. Okay, so when we concluded back in November, we adjourned this matter to allow the people to respond, to have a written response, and then we reserved our Mrs. Walker's argument until this hearing. We got further delayed when the court closed in December, but here we are. Ms. Walker, would you like to speak towards the defense's motion?
Yeah, Judge, just briefly, I know the court has read our response and I know the defense has received it as well. I know they filed a response to our response that I received late Wednesday, saw yesterday morning. Just very briefly, Judge, in this case in particular, there are, and I didn't count, 20-some defendants. They do not have anything in common for the most part. There are different days, there are different locations, there's different officers, which is completely contrary to their motion. Their initial motion that was served in line 3 indicates that they are requesting May 29th, 30th, 31st, June 1st, and June 2nd. Their defendants, for a matter of fact, have days of those four, also August 23rd, June 26th, July 16th, August 23rd, multiple days, multiple locations, multiple officers. But what they're asking at this point is to have all those cases dismissed, despite the fact that their original motion only requested discovery for 4 days. That discovery was provided to them in video format. It is what the people have, it's all the people have, it's all the police department has informed me that they have. As a matter of fact, yesterday I took the extra steps to meet with DPD's legal advisor and their use of force investigation director, Chris Graveland. They indicated to me there is nothing else that I do not have that I have provided to the defense. I would submit to the court based on their initial motion that I have supplied them discovery. I've given them what I have. I have no other exculpatory evidence, and I have met that burden. And that being the case, Judge, any dismissal of this would be unwarranted. I understand the defense feels if there's something I haven't given them, or maybe I haven't given them what they want, but dismissal in this case is not the remedy.
All right. Thank you, Ms. Walker. Mr. Royal, Mr. Chambers, Ms. Peterson, Cataray, and Leonard. Do you have anything you want to say as to Mrs. Walker's response?
Yes, Your Honor. Your Honor, I was confused by the city's position in these matters until a few days ago. We had oral argument before Judge Ruth Ann Garrett on the same motion pertaining to the cases, the protester cases pending on her docket. And now I think I understand what has happened here. Several months ago, myself and a couple of the others on our team had some off-the-record discussions with Ms. Walker, in which we mentioned that the majority of these tickets were issued by officers who were not involved in the arrest or present at the time of the arrest. And she indicated to us she was aware of that. What happened here is that these protesters were scooped up on the street and taken to one of three locations, either the Atwater Bates Police Station, the Little Caesars Arena, or the Detroit Detention Center. And tickets were issued by officers at those locations who were not present at the time of the arrests. And that's why we have certain officers who have written dozens of tickets for protesters for incidents that they have no personal knowledge of. Nevertheless, what we expected to receive in discovery was the identification of the actual arresting officer and an indication from the records of the police department whether that officer was wearing a body cam on the day of the arrest and what the status of the video taken at that time was, whether it still existed, and if it did, we expected to receive it. Instead, what we've received is a stack of videos of police body cams with names of officers and dates on them, but no indication as to which defendants of the cases being prosecuted these videos are relevant to. And in fact, the attorneys who viewed them, these are dozens of hours of videos, we've been unable to identify any of our clients in any of the body cam videos we've been provided. But the important information that we learned this week is that when we had previously discussed this with Ms. Walker, we thought she had told us that the police were able to identify the actual arresting officers because they used zip ties as handcuffs that had individual insignia on them identifying who the arresting officer was. When I mentioned this to Judge Garrett the other day, Ms. Walker spoke up and said that I was mistaken. In fact, what she had said is that she had discussed with the police department using this procedure in the future, but that in fact, the arrestees charged in the cases before the courts at this time, this procedure had not been followed. So what this means, Judge, is that the Detroit Police Department does not know who the arresting officers are for these protesters, neither does the City Law Department. And that's why we have not been furnished with any information as to the identity of the arresting officers or the status of their police body cams. So we're in a situation where we have no way to prepare a defense for these protesters. Most of these tickets do not contain any allegation as to what the protesters supposedly did to violate the law. Most of them simply quote the language of the ordinance, either the disorderly conduct ordinance or the loitering ordinance. And they don't say what this defendant supposedly did to break the violation. So we have no information from the ticket. We have no police reports because Ms. Walker has said that they don't keep police reports in misdemeanor cases, and we haven't been provided any. And we can't get the police body cam video because nobody knows who the arresting officer is. In addition to that, an argument before Judge Garrett the other day, one of my co-counsel brought up to the attention of the court and to us actually, the fact that 3 years ago, our state legislature passed a law that requires the preservation of the body cam videos under circumstances like this. The relevant statute is MCL 780.311 et seq, and it applies to all evidentiary audio and video recordings created by police officers while on duty of an event that includes a crime, an arrest, a citation, a search, a use of force incident, or a confrontational encounter with a citizen. And these are required under that statute to be preserved until the completion of the ongoing investigation or legal proceeding. So when these officers turned in their body cameras after a day of dealing with protesters in these cases, they were under an obligation to notify the police department hey, I made an arrest. I was involved in a confrontational encounter with a citizen. I issued a citation, or I told one of my partners to issue a citation. That created a legal obligation on the part of the police department to preserve the videotape of that incident until the completion of legal proceedings. So the debate that we've had in our pleadings over when our requests for discovery were filed is irrelevant. But even if that's relevant, the fact is we've now provided the court with copies of the Freedom of Information Act requests that our civil legal team provided the city on July 13th, notifying the city of the intention to file civil actions, and the city well knows of the tendency of these criminal matters. So they've been on notice to preserve these videos. So if they don't know who the police officers are, and they don't know where the videos are, and they don't know if they've been destroyed or not, how can these cases proceed? They can't. We're looking at a situation where this court schedules these cases for trial one at a time over the next several months. We show up, we prepare for trial, we show up, the police officer arrives and tells the city attorney trying the case, I wasn't there at the time of the arrest. I have no personal knowledge about this case. And the case gets dismissed, wasting the time of the court, the defendants, and the defense legal team. It is completely useless to not dismiss these cases because they can't proceed. We rely on the case that we submitted to the court of Gabriel Jackson, which is a case that came out of Judge Ulysses Boykin's court over in the Wayne Circuit Court, where in that case, and this was a 2009 case, so it took place before the new statute went into effect. In that case, the defense had obtained a court order to preserve the video, the police dash cam video. And when it came time for an evidentiary hearing, the prosecution couldn't produce it. And the Judge Boykin had a hearing and determined ultimately that the videos had been destroyed after the issuance of the court order and service of the court order on the police department to preserve the video. Based on that, Judge Boykin dismissed the case with prejudice, a felony criminal case dismissed with prejudice for the destruction of the video after a court order had been issued to preserve it. Went up to the Court of Appeals. Court of Appeals affirmed Judge Boykin in every respect, including specifically ruling on the fact that Judge Boykin did not abuse his discretion in dismissing the matters with prejudice. So that's the remedy we're asking for in these cases, Judge. There's no point in proceeding any further on these cases. They can't proceed. The evidence says, according to the city, can't be located, and if it can't be located, we can't go to trial. And I would indicate to the court that if the court's uncomfortable with dismissing with prejudice, the court has the other option of dismissing without prejudice and putting the burden on the city to come forward and request reinstatement when they can identify the actual arresting officers and indicate the status of the police body cam from that particular officer. So under these circumstances, we don't think the court really has much choice. These matters have to be dismissed. The only question is, should they be dismissed with or without prejudice? We ask the court to exercise its discretion and make an appropriate ruling. Thank you very much.
Judge, may I respond?
Yes, briefly.
Okay, thank you. In regards to the People v. Jackson, first of all, it's an unpublished case and the court can take that for what weight it wants to give it. Second of all, I believe it's distinguishable because in Jackson, the court determined that a video existed. In this case, we haven't determined that. We know that there were multiple videos that existed, but other videos, whether or not they existed, I don't know. Counsel doesn't know. We're all speculating. So I think Jackson is distinguishable. In regards to their FOIA claim, I had an opportunity to speak to the city's FOIA section after I discovered Monday during the same hearing that Mr. Royal has referenced with Judge Garrett that they had requested a FOIA. That was the first I heard of that. The FOIA department indicated to me that they sent a request back to the issuing requester, who was Ms. Hurwitz and Mr. Goodman, saying that they would need a deposit of $202.98 for DPD to conduct a search for their records. No deposit was received. The case was closed because the deadline was passed on October 6, 2020. The deposit was not complied with. The FOIA case was closed. At that point, the city was under no obligation to maintain anything. Further, Judge, I would submit that DPD's policy of a 90-day retention is in compliance of the law. When you read that statute piecemeal, yes, it does say that. you go a couple sections beyond that, and I don't have that in front of me, it indicates a 30-day retention is considered reasonable. DPD does 90 days. I would submit to the court that we more than meet that statutory requirement. Further, Judge, I want to go back to the fact that their initial motion requests 4 days of discovery. What they have in front of this court is defendants with other days of discovery. I do have other video for August 23rd, which I can provide them. What I didn't know, based on their motion, was that their clients were outside of that 4 days they requested. In their own initial motion, paragraph 3 requests 4 days of discovery. I have provided that. I can give additional discovery video for the August 23rd people that were not indicated in their motion were part of those days. That being the case, Judge, again, when I go back to looking at the totality of these circumstances, not only is dismissal not appropriate, I would say in regards to the people that were outside of those 4 days, that a new motion should be served on the people asking for that discovery, but I would be willing to waive that in regards to just providing them the August 23rd video.
Ms. Walker, I got a question based on what you just asked. And I noticed that back in November, because this motion actually started before, I believe, those matters that took place on the 23rd were even before this court. And correct me if I'm wrong, but I remember reading your response, and it's my understanding in the memorandum you indicated that there were some videos from the 23rd that were submitted after this incident, I believe in December.
Yeah, Judge, I submitted to Cripson Silver what I saw that I needed. I believe I've gotten a couple more in since then. I would need to look at what I submitted them. But for purposes of today's motion, like I said, it only requested 4 days. And a lot of these defendants are outside of those 4 days they requested.
I got, yeah, my main concern was the 23rd. I don't have anybody on the 22nd, but on the 23rd, I've got a number of folks. I've got one person on the 26th and one person, or strike that, 2 people on the 16th. And you indicated that you have videos for those days.
No, I do not. There's the only video that I have additional for is August 23rd, and I would need to look at what I provided attorneys Cripson Silver to make sure I gave them everything that came into me for the 23rd.
Okay.
Judge, this is Ms. Driver. We also need videos from the 23rd. I'm having a little bit of difficulty.
Wait, Ms. Driver, 1 second. Let me finish asking my question.
I'm sorry.
And then I'm gonna give you an opportunity to jump in. And while you're talking, just for clarification, your client, I got to say 23rd, but August 23rd and July 23rd, those are 2 separate dates that our folks have cases in this courtroom. But
Correct.
that being said, I got a couple other questions I need to ask.
Judge, clarification, I have video from August 23rd, not July 23rd.
Okay.
So Ms. Driver, I do not have video for.
Okay. Now also, you indicated earlier that the folks issuing the citation weren't necessarily the arresting officers. Are we able to identify the arresting officers or officers who have knowledge that, you know, anybody in any of these tickets were involved or did allegedly what we said that they did, or the city said that they did?
For the ones in front of the court for the days of May and June, I do not.
Okay. And I know we 1 second.
Just I go back to that is what was asked for in the initial motion.
Okay. Give me 1 moment. So I had a couple other questions that I wrote down. Oh, also witness list. I'm assuming at this point the witness list consists of the officers whose videos were submitted on the days of the incident, as well as the issuing officers.
That's correct, Judge. That would be all the people would be submitting.
Okay. All right. based on that, Ms. Driver, did you have any further questions?
No, just to say, Judge, that these cases have been out there for a long time. They are misdemeanor cases, but we should have gotten the discovery. It was not necessary for us to have to put in motions to request it. And I can say this, I've had two cases that actually went to trial. One of them, the officer showed up, could not remember anything. The other one, the officer didn't show up. And it's just it really is a consumption of a good deal of time of both the court, of the attorneys, and of our clients to continuously be coming back, even though I know in your court, you've said that they do not need to show up to get nowhere. And I feel like something needs to be done now.
All right. Thank you very much. I'm gonna take 5 minutes to make some notes, and I'll be back with the ruling.
Thank you, Judge.
Thank you, Judge.
Okay. I just wanted the chance to review 780 316 one more time. Make sure I had an understanding of what was asked for. But I've had a chance to pretty much read what you guys sent me, as well as hearing arguments as to these cases. And I start from the basic premise that folks need information to to go forward on these cases, to mount a credible defense. And when I look at what was presented, at first I see that there are at least 10 as to over multiple dates, there are a number of video recordings that were provided by the court. I mean, strike that, provided by the city. But what struck me was that and these are submitted as tickets, that the issuing officer wasn't in fact a witness to the alleged offense. And on top of that, none of the cameras related to anyone that was determined to be an arresting officer. And at this point there was, after, at least 6 months for the June and before cases, 6 still hasn't been determined. And that's a problem. That will lead me to believe that, there's no way to, to make a case that, the defendants could be proven beyond a reasonable doubt or responsible for the crimes in which they're charged with. So the fact that there aren't any indication of who actually, saw these incidents or any indication from the videos that were submitted that, the defendants were in fact in these, in the camera's view, I do believe that there is a default in the discovery. As to a retention of the videos, 780.316B is, well, starting with the whole statute. So 780.316 indicates that videos are to be saved no less than 30 days, but goes on to say that, if a video is possibly used in an ongoing investigation or criminal charges, then it should be saved during the completion of the incident. And we've only just begun. If we've got no indication that videos have been destroyed, but we also got no indication that videos were. We don't know who the arresting officers were, so we can't even make that determination at this point. So as to that, going on the cases dated May 29th, May 30th, May 31st, and June 2nd, I'm going to dismiss those matters without prejudice due to insufficient evidence. I'm also going to dismiss tickets from dates ranging June 16th, strike that, July 16th, June 26th, July 23rd, and August 23rd. While they were not captured in this motion, it's still the same problem. After this time, arresting officers have not been identified, and I don't believe that any of the evidence or the discovery that was submitted corresponds with someone indicated as someone with knowledge that this actually took place. So I'm dismissing these matters, or those matters, without prejudice as well. I am including cases for Ms. Bell and Mr. Bolger, as these requests were made at very least on the record. Going back from October, Ms. Driver and Ms. Smith have made requests for discovery, from the very beginning. And I do want to say this. I've been thinking about, People v. Jackson a lot. The reason I'm dismissing this without prejudice is partially because of that. Judge Boykins dismissed these cases with prejudice in a situation where there was a preliminary exam. There was an action that was, allegedly recorded by officers. The officers, at that time, the attorney asked that any evidence be preserved. And, when they got to circuit court and they later had an evidentiary hearing, then we learned that, the case, the video had been, destroyed or didn't exist at some time later. In our cases, we don't even know, who to point the finger at, whose videos, could possibly be destroyed or not. So, if, these cases are dismissed without prejudice, if the people just, are able to resubmit these cases with actual, folks who were involved with the arrests, then we can have that argument whether, they're, I'm assuming at this point their tapes, if they had a body cam, their tapes would be saved. And if they didn't have a body cam, there should be at least a record of whether, whether there was a body cam or not. But we don't even know who the arresting officers were at this point. So I there's no point of going forward with any of these. So these matters are going to be dismissed without prejudice in their entirety. I'm sorry.
The civil infractions? Civil
infractions as well. Civil infractions, the person that signs the ticket needs to be the arresting officer, or at least have firsthand knowledge that this took place. And that wasn't the case, at least from what you told me.
That was not the case for the May and June cases, Judge, what they asked for in motion. The other cases, specifically, I'm looking at the tickets you provided me for his driver's case. It has a different officer and it's listing specific instances of conduct, which I don't know whether or not that officer can testify to, because I wasn't served with a motion for discovery on these cases, nor were they contained within the date served in the motion that I did receive from the group of attorneys.
At this point, I'm going to dismiss these matters without prejudice. If it is determined that, the arresting officer on those infractions did in fact write the ticket, resubmit it, let us know. We'll go forward and deal with the case on the merits. But at this point, this matter was, they've been consistent this entire time. And, there's just, these matters aren't consolidated, but, the people should at least submit, or at least have knowledge on every particular case that they filed of, who exactly is charged and what they need to prove this case. And, I'm not sure we have that for any of these cases. So, at this point, the cases are dismissed. Of course, there's, right to appeal, but.
Yes, may we get a written order?
Yes.
Thank you.
Do you want me to submit an order for all cases collectively, or do you want individual orders for each case?
Individual orders for each case.
We'll take care of it, Judge.
All right. That concludes this hearing. There are two other people that are in the waiting room. I want to bring them in right now. Actually, let me put these on the record. All right. As to cases called today, previously placed on the record, these matters will be dismissed without prejudice due to insufficient evidence, argument laid or recommendation laid forth in my ruling. Cases are dismissed.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
Thank
and we
you,
will submit
Judge.
I get
Thank
the
you,
order
Judge.
together as soon as possible.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, everyone. No need to say thank you. If this case is concluded, I'm asking that you leave the room if you're not an attorney.